Alrighty, everybody. So this is just going to be a little short video. I thought I wanted to do a little introduction because today is a very, very important day in the Sarah Boone case, and she faces sentencing. So I think a lot of people are obviously, from what I can see in my comments and other people's comments, they're hoping Sarah Boone gets the book thrown at her today. But we're going to go over what she faces, what's the minimum sentence she's looking at, what's the maximum sentence she's looking at, and what are the factors that the judge is looking at. What are we looking at as far as what's going to be presented at the hearing? And then we're going to go over a motion that she filed, or that's outstanding, that the judge will rule on today as well, which is very important, which is her motion for a new trial and the likelihood that that motion is successful. So it's not going to be a long video. Probably I'm going to try to keep this within reason. And then we're going to begin live coverage on the channel at 1:30 today. So without further ado, let's jump in and let's start talking about the important issues here. So I think the first thing we're going to take on before we get into the sentencing is this motion that Sarah Boone has filed. And we'll put it up behind me right here. Let me move myself over. So you see this here. It's the defendant's motion for new trial. So there you can see she filed this. It's a 5-page document. You can find it online. And it's actually quite interesting. The allegations are as follows. These are the 5 reasons that she wants to have a new trial. So it says that the court erred in ruling that the defendant was not entitled to court-appointed counsel. The court erred in denying undersigned counsel's multiple motions for continuance. The court erred in failing to grant a new trial when the alleged victim's family caused an emotional outburst in open court in the presence of the jury prior to deliberations. And the trial court failed to disallow the opinion testimony of the state's rebuttal expert witness, Tanya Warner, MD, after the state failed to disclose before trial that the witness had formed a new opinion. And 5, the state committed prosecutorial misconduct by essentially making a second closing argument instead of a rebuttal argument. So do any of these have merit? They possibly do. I think the strongest ones are in, believe it or not, are in the denial of counsel. But we're gonna walk through these as the attorney for Sarah Boone, who said, by the way, he will not be involved in the appeal. He has said that he's going to see this through sentencing, and then he's going to turn it over. And if you don't know the background of the individual who took on Sarah Boone's trial in short notice, he was the #1 public defender in the county or area that he practices law in. And of course, right now, after doing that for, I think he said 20 years, I think it was, he is now in private practice. He says he has a thriving practice. From what I understand and looked at when I was looking into his background, that seems to be true. And he took on this case, shut down his law office, and did it simply because he could not believe that Sarah Boone was going to be forced into a trial to which without counsel, which under Florida laws, you're going to see when you look in this motion, this judge definitely is trying to set what we call precedent. He's trying to set new precedent in dealing with a defendant like Sarah Boone. So this is going to be an issue that almost 100% is going to be taken up by the appellate court, because normally, as you'll see, there's only 2 reasons why a defendant can be deprived of counsel, and Sarah Boone did not meet either of those. So this is a new territory to say that somebody like Sarah Boone, who's firing lawyers, who's unhappy with counsel, who has complaints, and the judge says the remedy for this is I'm going to deprive you of counsel, which is what they did. And then not only that, but it deprived her of effective counsel, because while depriving her of counsel for that period of time, no preparations were being done. And then the judge doubles down, right? When she gets counsel, he says, no more continuances, and you've got to get up to speed in essentially 6 weeks. And as as her attorney points out, that was a monumental task that he says he was not able to get up to speed like he needed to. He would have been granted the time necessary to have prepared properly. And then on top of that, the state's expert sandbags them by giving them, and I have the deposition. I'm not putting that up in today's video because it's too long to do. But there's a 95-page deposition that was taken the day before or a couple days before this lady testifies at trial, and she gives a totally different opinion in that deposition than what she comes to trial with, and the state fails to notify Sarah Boone's defense. So not only are they hamstrung and hands tied behind their back due to a lack of ability to prepare, lack of ability to get the witnesses together that they needed, the lack of ability to be able to understand the whole case through and through like this gentleman would have wanted, but now the state doesn't even play fair, you know? So I think there is some merit to this. Now, do I believe the judge will rule in Sarah Boone's favor? Absolutely not. This is the beginning process for Sarah Boone to approach this with appellate attorneys who will be appointed to her, and they will be able to take on the case and look into seeing if the appellate, they're most definitely going to want to rule on this, but will they carve out a third reason, the Sarah Boone rule, on somebody being deprived of counsel? Now, most states, you wouldn't even dare touch such a sacred right. But Florida is a little different. Remember, Florida is willing to extend the death penalty past unaliving cases, and they impanel 6 people juries for felony cases. So they're willing to step out and do things that are a little bit outside the box. So if there's a state that's going to do this, it's going to be Florida. So anyways, let's go through the arguments here. In the above styled and numbered case, the defendant had approximately 7 court-appointed attorneys. The above case was very complex, even for a seasoned trial attorney who was the public defender of the First Judicial Circuit for years, as well as having a thriving private practice. It was apparent to the undersigned trial counsel that Ms. Boone would be grossly ill-prepared and unequipped to handle a trial in this matter, or in fact, to handle any other phase of the trial without counsel. Both the Sixth Amendment as well as Rule 3.11 Florida Rules of Criminal Procedure guarantee an indigent defendant the right to appointed counsel. It goes over several state cases that support this: Bowden versus State versus Kelly, and progeny. There appear to be 2 exceptions to this precedence. 1, if the defendant physically harms or threatens to harm his or her counsel, and 2, if the trial court certifies that the defendant will not be incarcerated if found guilty, i.e. a judge trial. Should the court determine that the defendant is not entitled to court-appointed counsel due to misbehavior on the part of the defendant, the court must follow a process which protects the individual's rights to due process, as well as the defendant's right to the assistance of counsel. In the instant case, undersigned trial counsel would assert that Ms. Boone's behavior did not rise to the level of misconduct to warrant a waiver of the right to court-appointed counsel. And if the court determines that she waived the right to court-appointed counsel, then the court failed to warn her or inform her that continued misbehavior could result in the waiver of the right to court-appointed counsel. Under controlling precedents, failure of the court to appoint trial counsel can result in a motion for new trial being granted. And then there's a couple of cases: Figueroa, Sanabria versus State, Wilson versus State, and progeny. Under controlling precedents 3.11111, Florida Rules of Criminal Procedure, in the Sixth Amendment, the defendant, through counsel, moves the court for a new trial. Argument 2 is the court erred in failing to grant the defendant's motion for continuance made by undersigned trial counsel. The court shall not deprive a defendant of his or her right to counsel of their own choice. Failure of the trial court to grant a continuance will result in a new trial should the court deny said motion for continuance by new counsel. And this is supported by Peraza v. State, McKenzie v. State, Jones v. State, and Deal v. State. In the instant case, when undersigned counsel came on board, the case was 4 years old. Undersigned counsel filed his notice of appearance on August 30th. This gave counsel 45 days to prepare for a second-degree unaliving trial. He immediately and aggressively began to prepare for trial. Undersigned counsel did his best to prepare for trial by traveling to Orlando from Milton on multiple occasions for meeting with Ms. Boone and attending multiple hearings. Despite his best attempts to prepare for trial, it was impossible to adequately prepare for the trial to adequately prepare for unforeseen issues arising during trial. A prime example of this would be reviewing hundreds of pages of text from Ms. Boone's seized cell phone, viewing all records of prior contact of Ms. Boone and the alleged victim with law enforcement, and including inadmissible hearsay by the alleged victim to law enforcement regarding Ms. Boone being the aggressor at times. Counsel, for all purposes, closed his law practice down to prepare for the trial, but due to the short time frame, even with the assistance of other attorneys, was simply logistically unable to be as prepared for trial as he would have liked to be, and as Ms. Boone was entitled to. Under the controlling cases cited, supra, the court's failure to grant undersigned counsel's motion for continuance should result in a trial. So this is very important as well, because one of the things that did it for me was when when the state, remember, did that dump of cell phone data, of videos, of text messages, of all these things that was said by the defendant. And again, as her attorney points out, he was not able to vet those and put those through the normal process of analyzing it and saying, is this hearsay? Is this admissible? Is this not? So it was just brought in. He was sandbagged with it. He didn't even know it existed. And he ends up opening up again. Had he been aware of this because of the volume of stuff? Now, again, should he have been aware of it? Of course. But he didn't know. He's trying to prepare all these different defenses. So he puts her on the stand and then opens it up to an exception to the rule to say, wait a minute, this would have been inadmissible hearsay, which is why Sarah Boone might not have testified. Or maybe she would have testified, but maybe she wouldn't have gone into certain areas or details. Or maybe there would have been an adjustment in her defense at trial. Or maybe there would have been a challenge to each some of these individual items to say this is too prejudicial. In other words, the value of this in terms of the evidentiary value of her guilt is outweighed by the inflammatory nature of it that could inflame the jury against Sarah Boone and would make the jury so enraged at her that they would lose the purpose of it, which the purpose of it was to simply demonstrate, some of these things were to demonstrate the, I guess, the fact that there was that it appeared to be a give and take relationship when it came to the abuse, which is what the state was claiming. So again, some very important, some big evidence came in, according to this attorney, who says it came in because of my lack of ability to prepare, my lack of ability to be aware, and the sheer volume of information and evidence that was impossible to become aware of. Next is the court erred when it denied a motion for new trial due to an emotional outburst in the presence of the jury. So this just goes over that they moved timely for a mistrial. We all saw that. And the judge said, nope, the judge failed to do anything. So what he says is, since the jury wasn't questioned about it, since there was no ability to know whether or not the jury was affected by this outburst, since the judge just chose to ignore it, then the only remedy for this is a new trial. Now, again, do I think the judge is going to give a new trial on that? No. But could an appeals court? It's possible. They'll give weight to it. The court erred in allowing the opinion of the state's expert not previously disclosed. Now, this is a big one. We knew at trial. We knew this was coming up. We knew this was a situation where the judge spent some time trying to determine how they were going to move forward, and he chose to allow that expert to come in, which is a key situation because this is one of those things where, if not for her testimony, Sarah Boone would have been acquitted. So this is a major, major piece where the appeals court would look at this and say, well, yeah, if the judge would have ruled they violated discovery and that they weren't timely notified, and she wouldn't have been allowed to give that opinion to the court, then we're going to we'd probably be having a not guilty verdict. So that would directly affect the verdict. And then you have argument 5, which is the prosecutor committed misconduct by using rebuttal argument to make a second closing argument. In other words, rebuttal is supposed to be a response to the defense, and they went out and just reclosed and re-argued the entire case. I don't know how strong that one is. He doesn't state any case law for it. This is kind of the opinion of him. So this would be something that it would be reviewed by the appellate court. I believe they may have violated some time frames in the amount of time that was allowable. I didn't even realize this happened. I've got to go back and rewatch the state's closing and get an opinion myself on that. But I thought that was an interesting one. So that is going to be the first thing that the judge is going to deal with. And then the next thing that the judge is going to deal with. Mindy asking, or one of the next. And then the next thing that the judge is going to deal with, obviously, will be sentencing. So let's go into that. And then, like I said, this is not going to be this doesn't require really a long stream, a long video here. But we're going to pull that up. So what is Sarah Boone? And we'll move me over to this side. What is Sarah Boone facing in this case? So she's facing 16 and 3/4 years to life. Now, understanding this, many of you would say, oh my gosh, she's going to go away, throw her away for life. I don't think the judge is going to do that. Understand that when life is imposed in Florida, it's no parole. There isn't a parole. There isn't a life with parole. It's either you're going to get a fixed sentence of some sort, or you're going to get life and you're going away for life. Now, the judge is going to have a couple of things to determine in this case in terms of looking at what he decides to give her, because there's going to be two overriding factors and the judge has to make a decision on whether or not they cancel each other out. One is the amount. Essentially, she had this man, Jorge Torres, in a position to where he was in this suitcase and she basically made him suffer. She had a duty to care for him in a sense, but she has him in this suitcase. She's in a position of power, and she essentially just lets him sit in his suitcase and suffocate to death. That alone could be an aggravating factor that would allow them to give her life. However, her attorney, and as we already know, he's already told the press he plans to bring in her doctors. On the other side of this is all of the stuff the judge has already heard, but there is some things that didn't come before the jury. That's what the doctor's going to be allowed to testify for today, are going to come in speaking to exactly what Sarah Boone experienced at the hands of Jorge Torres as someone who was an abused individual. Now, remember, there was the countervailing information and cell phone footage which came in, which the judge is fully aware of, showing that Sarah Boone was almost an equal aggressor towards Jorge Torres in a sense, and she was abusing him too to a degree, and she was manipulating him. So the judge has to put weight on that. But I think that's going to be the difference. I don't think he's going to give her life without parole, because I think he's going to understand that Sarah Boone, in this case, there is that aspect of abuse. I think, in my opinion, I think he'll give her 30 years. That's what I think will happen. Now, in Florida, 30 years means she'll probably serve roughly about 20 to 25 before she would be eligible before she'll get released. But I think that they were offering her 15 as a plea bargain. Remember, I think he'll double it because she went to trial. That's what I think. So you put in the comments what you think. I think it'll be 30 years. I think it's going to be about a 3-hour hearing. That's what they said they allotted. We're going to hear from Sarah Boone, potentially. I think she's going to probably, in this kind of a case, she can say she's sorry for the outcome and the results. I think she's going to speak. I think that we're going to hear from the doctors that's going to talk about her mental framework. I think you're going to hear from Jorge Torres' family, and you're going to hear some emotional statements from them, talk about the devastation of what happened with Jorge Torres and the impact his death had. And then I think that's it. You're going to see the whole thing is going to be wrapped up, I think, probably, in about 3 hours. There's not going to really be there's not an opportunity for a downward departure or mitigation or anything like that. Well, there is mitigation, but not a downward departure, I don't believe, because she took it to trial. So I think she loses the ability to ask for a downward departure. Now, there is mitigation to the sentence where they could say, don't give her life, give her 16 and a third, 3/4 years, but she's going to do time in prison. She's going to do far more time in prison, I think, than if she would have pled out. And I don't think the judge is going to say, well, we're going to give you 16 years You get 1 extra year. I think he'll double it. I think that's a fair thing. And given the fact that she was somebody who also was abused by George Torres, now she also did her own stuff back, but I think that's a great place to settle on. So you let me know what you think. Like I said, we'll be covering this in a couple of hours. 1:30 is when it starts. Tune in, come in, talk to me. Let me know in chat. I'll be there watching, and we'll be there to see exactly what this judge does, what Judge Kranick does today. It'll be very, very interesting. So until then, guys, I'll see you in court, and hopefully justice will prevail today for Sarah Boone as in George Torres as sentencing proceeds. So I'll see you in court and talk to you soon.